In this lecture, we are going to be covering chapters 7 and 8 in our Medical Law and Ethics textbook. Public health records and vital statistics. This is information that contains important events in a person's life, which are used by government agencies to determine population trends and needs. The information can help to establish mortality rates, morbidity rates, and it is the public duty of physicians to report vital events. A physician must sign the certificate of a live birth. The certificate is filed at the county clerk's office of the state in which the birth took place. Death certificates must contain the date and time of death, cause of death, how long the deceased was treated before dying, the presence or absence of pregnancy, and whether an autopsy took place. The death certificate usually must be signed within 24 to 72 hours of one's death. It must contain proof that a death has in fact occurred. This is often required, the death certificate, to confirm information in regards to settling the deceased estate. A coroner is a public health official who holds inquest if death is from an unknown or violent cause. The medical examiner is a physician who investigates unexplained deaths by performing autopsies. An autopsy is an examination of the deceased body after death to determine the cause and manner of death. Certain types of death require a coroner's signature. If there was no physician present at the time of death, if the death was violent in nature, such as a homicide, a suicide, or an accident, if death is a result of a criminal act, or if death is from some type of unlawful act, such as assisted suicide. Other deaths that require a coroner's signature: the result of undetermined causes, deaths caused by electrical, radiation, or chemical injury, deaths caused by criminal abortion, including self-induced, and deaths occurring less than 24 hours after hospital admission. Deaths of a person who had no physician in attendance within 36 hours of death, death occurring outside a hospital or licensed healthcare facility, any suspicious death, such as a fall. Deaths of a person whose body is not claimed by a friend or relative. Death of a person with an unknown identity. Death of a child under the age of 2 if death is from unknown causes. Death of a person in jail or in prison. Communicable diseases are diseases transmitted from one person to another. They are considered a threat to public health. Physicians must report to public authorities the patient's personal information, the name of the disease, the date of onset of the disease, and the name of the person making the report. National Childhood Vaccine Injury Act requires that childhood vaccines be administered as required by law. Duty to report AIDS, HIV, and ARC cases. All states require reports of these cases to local or state departments of health, who shall report the case varies from state to state. Could be the attending physician or laboratory, etc. Many states have confidentiality statutes regarding these reporting requirements. Disclosure to patients of health workers' HIV status. Healthcare workers consider disclosure an invasion of privacy. All blood and tissue donors tested. Patients have a desire to know if they are at risk of HIV infection. Child abuse. All abuse must be reported by teachers, health care professionals, law enforcement, and daycare personnel, and social service workers. It is a probable cause determination as to whether or not there is potential child abuse. Physicians have been held liable for failing to report suspected cases of child abuse. The person reporting alleged or suspected child abuse is protected by law from being sued by parents or others. Types of child abuse include battered child syndrome, parental neglect, elder abuse is covered under the Older American Act of 1987. Includes physical abuse, neglect, exploitation, abandonment, and financial abuse of adults 60 years and older. It protects residents of nursing home facilities, and it protects elders against financial abuse or exploitation. Spousal abuse are laws governing the reporting, and they vary from state to state. Local police may have to become involved when spousal abuse is suspected. Courts may issue restraining or protective orders prohibiting an abuser from making contact with the victim. Signs of abuse include repeated injuries, bruises and unexplained swelling, signs of inadequate nutrition, unexplained fractures, bite marks, or unusual markings on the body. Other signs include bruising or swelling in the genital area, venereal disease and genital abrasions, makeup to hide bruises, or sunglasses worn inside to hide blackened eyes. Substance abuse. Abuse of prescription drugs is reportedly should be reported immediately according to law. Violation of controlled substance laws is a criminal offense. Gathering evidence in cases of abuse, precise documentation of all injuries, bruises, and suspicious genital fluid deposits in children is critical. A court may subpoena records at a later date. Other evidence includes photographs, urine specimen, clothing, bodily fluids, various samples such as blood, semen, vaginal or rectal smears, foreign objects, and it's also very important to document the chain of custody of this evidence. Other reportable conditions: physicians are required to report certain medical conditions to maintain accurate public health statistics, including cancer, epilepsy, congenital disorders, and certain infectious diseases such as TB or tuberculosis. Controlled Substances Act and regulations. This is covered by the Food and Drug Administration, the FDA, the Drug Enforcement Administration, the DEA, the Controlled Substance Act of 1970, and the Bureau of Narcotics and Dangerous Drugs, BNDD. Prescription of controlled drugs: only those with a DEA schedule may issue prescriptions for narcotics. Number must appear, the DEA number must appear on all prescriptions for controlled substances. Schedule II drugs require triplicate forms. Schedule II drug prescriptions cannot be refilled. One must take a written inventory of drug supplies every 2 years. Narcotic dispensing records must be kept for 2 years. State regulations may vary. Prescriptions for controlled drugs: compounding, dispensing, retailing, and the defining of these drugs are all going to be controlled and regulated. A drug is intended to affect the structure or function of the body of a human being or some animal. Protection of employee and the environment. Employee Assistance Program, or the EAP, provides confidential counseling and referral services, helps employees and their families assess a problem, develops a plan to resolve problems, and determines appropriate resources to assist in the process. Medical waste can be solids, chemical. The proper disposal is going to be required. Material safety data sheets are going to have to be filled out. These also include radioactive and infectious waste. Chapter 8, Workplace Law and Ethics. Professionalism in the workplace. Discrimination must be avoided. You cannot violate a patient's privacy. You must show respect for cultural differences and religious practices. Health Insurance Portability and Accountability Act of 1996. Opening a patient's medical file should always be on a need-to-know basis. It is inappropriate to look at a coworker's personnel file. Cultural considerations include background and experience of which heavily influence personal beliefs, stereotyping, bias. You do not want to judge another person. Different cultures have their own practices for personal hygiene. Ethnocentric people, communication can be a challenge for many people who do not understand English. Non-English speaking patients need brochures and handouts in their own language. Cultural restrictions can pose difficult situations. Religious considerations. You must consider a patient's autonomy. Conditions can result in confusion for the medical professional. Guardianship of minors may have to be established. It is never appropriate to judge another person's customs or beliefs. An employer has a legal obligation to accommodate religious practices. Effective hiring practices. You must develop clear policies, use a two-tier screening process, provide job descriptions, use a progressive disciplinary process, and document all disciplinary procedures. Be familiar with legal and illegal interview questions. Questions that may come up in an interview may be one's age, birthplace, address, marital status, and maiden name. Other interview questions: whether or not a person has children, a person's height and weight, race or color, religion or creed, or whether or not they've been arrested. Keep in mind, it's illegal to ask questions for determining whether or not an employer is going to hire somebody based on religion or creed, race or color, whether or not they have children, height and weight, and what their maiden name is. It may be illegal to determine whether or not someone's going to be employed based on their age and birthplace. It's legal to ask questions regarding citizenship, whether or not a person has been convicted of a crime, what languages a person speaks, and whether a person has military experience. You can also ask a potential employee about organizations they may be a member of. However, it would be illegal to not hire somebody based on their organization affiliations. It's also illegal to base employment on whether or not somebody is handicapped. Federal regulations. These are government regulations regarding employment. Healthcare facilities and medical practices must remain current on the federal regulations. Keep in mind that federal law preempts or overrules state law. equal employment opportunity and employment discrimination, laws that affect recruitment, placement, pay plans, benefits, penalties, and termination. People must be judged primarily by job performance. Employment at will. Employment takes place at the will of either the employer or the employee. Employment may be terminated at will, meaning it can be terminated at any time and for no reason. An employee may quit at any time and for no reason. Exceptions for a specific employment contract in which employment cannot be terminated during the contractual period. Title VII of the Civil Rights Act of 1964 prohibits discrimination or unfair treatment based on race, color, religion, gender, or national origin. It forbids discrimination in all aspects of patient care in institutions that receive federal financial assistance. It makes sexual harassment a form of unlawful discrimination. The Equal Employment Opportunity Commission, or the EEOC, regulates violations of Title VII of the Civil Rights Act, and it also regulates affirmative action programs. The Civil Rights Act of 1991 permits a court to award both compensatory damages for the loss of income and or emotional pain and suffering, and punitive damages designed to punish the defendant and deter others from practicing discrimination. The EEOA of 1972 also authorizes suits on behalf of persons whose Title VII rights are violated. Pregnancy Discrimination Act of 1978, employers must treat pregnant women as if they would any other employee, providing pregnancy does not hinder job performance. An employer cannot force a woman to quit her job because she's pregnant. It ensures equal treatment in areas of disability, sick leave, and health insurance. The Age Discrimination and Employment Act of '67 protects persons 40 years and older against discrimination, applies to employers with 20 or more employees. Mandatory retirement is prohibited except for certain types of employment, such as airline pilots. Rehabilitation Act of '73 prohibits discrimination based on disability in institutions that receive federal financial assistance. Hospitals that receive Medicare or Medicaid must comply with this law. Americans with Disabilities Act of 1990 prohibits employers who have more than 15 employees from discriminating against an individual with disabilities. Employer must make reasonable accommodations for those with disabilities. The exception would be if it caused an undue hardship for the employer to make those accommodations. Those who have AIDS are protected under this statute. National Labor Relations Act of 1935 gives employees the right to form and join unions, to bargain collectively, and to strike for better benefits and working conditions. The purpose of this law is to protect employees. The National Labor Relations Act also establishes rights for both employees and employers and defines some prohibitive acts by employers called unfair labor practices. This is also called the Wagner Act. Employee health and safety is regulated by both federal and state laws. State law may be stricter than federal, but it cannot be more lenient. The Occupational Safety and Health Act, or OSHA, of 1970. An employer is required by law to provide safe and healthy work environments. It must protect workers against hazards, occupational exposure to bloodborne pathogens. Standards refer to urine, stool, sputum, nasal secretions, vomitus, and sweat if there is visible evidence of blood. Clinical Laboratory Improvement Act of 1988 and then amended in 1992 requires regulation of all clinical laboratories that test human specimens, mandates written policies and procedures for comprehensive quality assurance programs. Health Maintenance Organizations, or an HMO, Act of 1973 requires a company with 25 or more employees to provide HMO alternatives to regular group insurance if the HMO is available in the area. Under a HMO, a patient has limited choice as to which doctors he or she can see. Patients may have to get a second opinion and permission from the HMO for major procedures. Consolidated Omnibus Budget Reconciliation Act, or COBRA, of 1985. A company with 25 or more employees must provide extended health care insurance to terminated employees for as long as 18 months. Usually this is at the employee's expense, and COBRA coverage is usually more expensive than your normal health care premiums. Drug-Free Workplace Act of 1988. Employers contracting to provide goods or services to the federal government must certify that they maintain a drug-free workplace. Employer must inform an employee of the intent to maintain a drug-free workplace and of any penalties employees would incur for a violation of those policies. The Social Security Act of 1935 laid the groundwork for unemployment compensation. This is paid into by the employer and the employee, and it's composed of several programs. One's retirement is based on the average wages contributed during your working career. Fair Labor Standards Act of 1938. This regulates employee benefits. It established minimum wage, requires pay for overtime, and sets the maximum hours employees can work. It covers non-management employees in for-profit and not-for-profit institutions. It affects only full-time hourly employees. The Equal Pay Act of 1963 is an amendment to the Fair Labor Standards Act. It is illegal for an employer to discriminate on the basis of gender if they are performing substantially the same job. Equal pay is required. Unemployment compensation. Employers pay taxes into a state compensation plan. Covers employees unable to work through no fault of their own. such as if they were laid off or terminated, provides temporary weekly payments for unemployed workers. If fired for good cause, the employee is not entitled to benefits. Federal Insurance Contribution Act of 1935, employers are required to contribute to Social Security plans for employees. Employees must contribute as well, but at a lower rate. A severe fine will be issued if payment is not made on time. It requires detailed record keeping. Workers' Compensation Act protects workers and families from financial problems resulting from employment-related injury, disease, or death. Employers pay into a fund to help cover costs when an employee has a work-related injury or disease. The goal is to get the employee back to work as soon as possible. Employee Retirement Income Security Act of '74 regulates employee benefits and pension plans. It guarantees vesting, which is a certain point in time when an employee has a right to receive benefits from a retirement plan. The Family and Medical Leave Act of 1994 allows a mother and father to take leave of absence of up to 12 weeks in a 12-month period when a baby is born. A job or equivalent position must be available when an employee returns to work. Under the Family and Medical Leave Act, leave is almost always without pay. Also allows leave for a family member's medical or family-related situation. So if one spouse is diagnosed with a serious illness such as cancer, one can apply for leave under the Family Medical Leave Act to help take care of that family member. Emergency Medical Treatment and Active Labor Act. This is a section of COBRA, forbids patient dumping from one hospital to another if the patient is unable to pay, and it protects patients who cannot pay. The Fair Credit Reporting Act of 1971 established guidelines for use of individuals' credit information. If denied credit, a consumer must be notified and the agency must disclose credit information to the consumer, who may correct and update the information. It prohibits businesses from granting credit based on race or gender. Women and minorities must be issued credit if they qualify for it. Truth in Lending Act of 1969, Regulation Z, requires full written disclosure about interest rates or finance charges concerning payment of any fee that will be collected in more than 4 installments. It prohibits unfair collection practices by creditors, institutions, or persons who are owed money. Credit collection phone calls can be made only between the hours of 8 a.m. and 9 p.m. Monday through Friday. It prohibits telephone harassment and threats. Using a collection agency. Professional collection agencies are available when all other attempts to collect a bill fail. Agencies charge a flat fee per account or a percentage of the amount collected. Once a patient is told an account is going to a collection agency, it must, by law, go to that agency. Once the account is turned over, no further collection attempts can be made by the physician's office or the hospital. Bankruptcy is when a person is unable to pay debts. They may file for bankruptcy. It provides some protection to debtors. It establishes a fair method for the distribution of the debtor's assets to creditors. Assets are placed in a special fund by a court-appointed trustee, then distributed according to a predetermined method. Federal Wage Garnishment Law of 1970. Garnishment is where a court order requires the employer to pay a portion of an employee's paycheck directly to one of the employee's creditors until the debt is resolved. It restricts the amount of paycheck that can be used to pay off a debt. Claims against estates. When a patient dies, bills should be sent to the estate of the deceased. Generally, specific time limits allow when filing of a claim of an estate can be made. The statute of limitations defines how long medical practice has to file a suit to collect on past due accounts. It's important to attempt any debt collection as soon as possible. This concludes our lecture on chapters 7 and 8.